No, it's always nice to be here. I love coming to the West St. Gabriel board. I'm grateful because back in 1994, this was the first board that invited me to speak late in that year. So I always feel a great loyalty. When this board asks me to come to a seminar or a talk, I say yes. I don't say maybe. So I'm happy to be here. And Albert tells me that I have 2 hours today to talk about disclosure. No, I need to compress? Okay, no, I understand. Well, let me jump right into it. There are two basic areas of lawsuits that most commonly are pursued against your profession. I guess I can almost say our profession because I do hold the broker's license. That's really so I can know what you guys go through. But there are two main lawsuit areas that are against realtors. One is the failure to reasonably inspect, the visual inspection. I think I've talked to you over the years a couple of times about that. The other one, though, is disclosure. Disclosure and inspection. Those are the two main areas of claims against real estate professionals in California. So I'm going to talk about disclosure this morning. And I think that sometimes in practicing real estate, we listen to our friends and colleagues tell us things about the law which aren't true. And what a tragedy if somebody who thought they were helping us actually tells us something about real estate law and disclosure that is inaccurate and leaves us exposed to a possible lawsuit. Morning. It's always good to see old friends around the room, so I'm sorry I'm calling people up. Anyway, so let's talk this morning about some specific disclosure issues very briefly. Some of these disclosure myths are kind of like, what do you call zombies? You ever see those zombie movies where you know you hit the zombie with a shovel and it looks like they're dead and they fall down and then they get back up and then you shoot them with a gun and they get back up? Some of these disclosure myths, as a lawyer who's been fighting these now for about 20 years, out of my 30 years of practice, I feel like these are zombie myths because I can't kill them. So let's try this morning. The first one is this. It's okay, I don't need to worry about disclosures on this particular property because it's being sold as is.
Yes.
That's a myth. Now, the real estate purchase agreement, the residential purchase agreement a couple of years ago added to it an as-is clause. Now, you know, for many years, CAR did not want to have an as-is clause in the RPA. And I'll tell you why. It's because they were worried that it might lull realtors into a false sense of security that, well, I don't really have to worry about disclosures on this one because it's as-is. Well, I don't know what changed over the last couple of decades where they felt comfortable in the last major revision of the RPA to put the as-is clause in it, but it's there. It's there. Now, the problem with that is, though, is that as-is does not affect disclosure legally at all. They're two completely separate concepts, and let me explain. In California law, there are three basic ways you can have a legal responsibility to somebody. One is you have a contract. I agree to buy from Nancy. Hey, good morning. See, as I told you, I call out over. I agree to buy from Nancy a piece of property, and she agrees to sell to me for a certain price on certain conditions. There's a contract. We have voluntarily made that legal obligation between us. Another one is a statutory obligation. An example of that is Civil Code 2079. That's your inspection responsibility. The law has placed upon you a specific responsibility. We have no choice in that matter. The law says you've got to do a reasonable visual inspection of a residential 1-4. The third kind is what we lawyers call tort responsibility. And that's when I'm getting here this morning, if I was behind schedule, and I was trying to drive too fast in the rain, and I ran through a stoplight, and I hit somebody in the intersection, okay? I'm driving carelessly. I have no legal relationship or agreement with that person whose car I crashed into, but the law says I have a responsibility to avoid taking actions that might hurt people around me. So that creates a responsibility of what we lawyers call due care or reasonable care. And so that's kind of a legal promise between me and everybody around me. If I were to wildly swing my arms right now and I was to hit Helen, well, I'm being careless. We don't have a contract that I say, I won't hit Helen. But obviously it's not right that I could be careless and wind up hurting her. Well, that's another example of this, what we call negligence or reasonable care violation. Now let's go back, having reviewed those three responsibilities, what does as is affect? As is only affects one of the three responsibilities. As is affects the contract agreement, the one between Nancy and I. That's the only thing as is affects. It does not affect my statutory responsibilities, like my 2079 responsibility to inspect. Totally different. It also does not affect my responsibility to take reasonable care and to avoid injuring people. Well, that's where disclosure comes in, because the law of negligence and the law of fraud is completely separate from the statute and from contract. So the as-is agreement may affect the contract promises, but it doesn't affect my responsibility to tell Helen, oh, by the way, before we close escrow, you need to know this house was built on a toxic waste disposal site. Okay? She might want to know that. So I can't use as is to say, oh, tra-la-la, I don't need to worry. Just put on the transfer disclosure statement, just put house being sold as is. Okay? So that's a terrible, terrible myth. Don't believe people when they tell you, oh, you can relax because it's as is. Now under the RPA, everything's as is. Okay? So you still have to do your inspection. You still have to be very careful to do your full disclosures, and so does your client. All right. The next myth I want to try to kill is this one. Well, I know there's a problem with the property, but I'm going to put on the disclosures simply buyer to verify. I know there's an illegal addition to the back of this property. You know, the old traditional, first they poured a patio, then they put a patio cover, then they put some walls around it, then they put a door on the wall, then they carpeted the floor, right? Yeah, over about 10, ta-da, bedroom! Okay, and of course the city of San Gabriel, the city of Rosemead, the city of Harman, the city of Pasadena says, what room? Okay? We can't cover ourselves by putting buyer to verify. Okay? That does not protect us from the duty to disclose what we know. If we know that there are code problems, building permit problems with a property, we have to disclose what we know. In fact, let me tell you, if you know about a problem with the property, and you may not know the full extent of the problem, I understand that, but you have to disclose what you know. If you know there is some degree of permit problems with the property, you have to tell what you know. You may want to additionally say, buyer should investigate this. But that does not cover you from telling what you know. This actually happened, and this wasn't a realtor in the West San Gabriel board. And I won't use names, but a person in my office almost bought a property a number of years ago in Altadena. And during escrow, it was revealed that the swimming pool and some small shed or something were not permitted by the County of LA. And so the buyer and the seller, the guy in my office, the buyer and the seller, went back and forth, and the seller finally said, well, I'm not going to pay for getting this permit, and I'm not going to discount the price, too bad. So my colleague canceled the transaction. And the realtor, the listing agent, said to him, well, fine, buy another house. I'm telling you, we're going to sell the same price. We'll just say buyer to verify permits. That's terrible. Because if you say buyer to verify to try to cover up or to excuse the actual knowledge you have, you're actually putting further guilt on yourself when the buyer finds out that you did know there was a problem. Because instead of telling the truth, you said, go look. Whoa, that sounds like you're trying to cover up something that you actually know is a problem. So what I'm saying, folks, is do not confuse your good advice to the buyer. Hey, we don't know what the square footage is. You've got to measure it. We don't know the exact permit status of this property. You need to investigate it. We don't know what's going on with this roof that keeps leaking. You need to check it out. No, go ahead and say those things. But you also have to pass along what you actually know. If you know the house isn't 2,400 square feet, you've got to say that. The house is not 2,400 feet. It has not actually been measured. We don't know, but it's not what the assessor says it is. You've got to say that, okay? So again, don't fall for that myth. We still have to say what we know. Here's another one that I get a lot from teaching the GRI class. I always have people ask me, well, what if I know something, but I don't know it from the seller? Do I have to pass it along?
Yes.
Right, exactly. Does your brain have a partition that says, okay, only stuff from the seller goes over here, and everything from the rest of the world goes over here? Here's how this came about. This is one true story. A realtor, a very fine, upstanding realtor, had listed a house years ago in which there was a problem. I think it was something bad, like a murder. And the house had sold, and then the house came on the market again about 8 years later. And this realtor was asking me, well, I know the seller's not disclosing this. Do I have to disclose my knowledge to the buyer?
Yes.
Yes, you do, absolutely. Knowledge is knowledge. Truth is truth. There's only one kind of knowledge, right? There's only one kind of truth. And so if we know, because perhaps you've been farming a particular area, you have a lot of knowledge about particular properties, you may have handled something with that property years before, you may know something about the property from the news, whatever knowledge you have, folks, there's no partition on truth. We have an obligation as professionals to tell people the truth about the properties that we're representing. So, if you know something, you've got to pass along no matter where it comes from. How about this one? I don't need to ask questions. Well, that used to be true. That used to be true. The case that led to Civil Code Section 2079 was a Supreme Court case where the court said, could a realtor walk into a property and basically do this as they're walking around? Well, I don't see anything here. Helen, could you just go ahead and sign that paper? I've got nothing I need to disclose. No, obviously, that's silly, right? And so the California Supreme Court said, yeah, obviously, a realtor has to disclose what they reasonably should know as they're doing a normal walkabout through the property. And that led to the enactment of Civil Code Section 2079, and what I often refer to as the bullseye on the back. So, if I have time, I'll take questions at the end, but I am on a short budget. I don't want to skip any topics. Anyway, the other thing that happened was the Field versus Century 21 case. That's a case that scares us real estate lawyers a lot, because it's a very open-ended decision. What happened in that case was the realtor that was involved in listing the property, there was a slope, and the slope had a bunch of fissures or big cracks in the slope, and it looked like something was happening. And the realtor who wasn't a soils expert just went ahead about the transaction. The claim against the realtor was, well, wait a minute, you should have protected me, the buyer. You should have warned me somehow that I needed to get an expert. And so the appellate court in California said in this Field decision, there are circumstances where you might have to tell a client that they need to do something more. That you might actually have to tell a client they may want to have an expert look at this. So that's a scary case for all of us, because the courts have not really followed that yet, and it's still hanging out there. So be alert, realtors. If there's something big going on, you need to make sure you recommend your client get the appropriate expert to look at it. Will they follow your advice? Probably not. Will they get a lawyer to look at a contract when the contract is a non-car contract or there's something unusual happening other than the normal RPA? Will they follow your advice? No, they won't. Typically, they will not. I charge $450 for a consultation to look at contracts for an hour and a quarter. And lots of people know about this. And I know a lot of you recommend, well, go get a realtor like Richardson to look. People don't do it. So when you know there's a problem with a property, there's a question, a hillside that looks like it might be slipping, structural, big cracks in a home, okay? A legal issue, the contracts look a little strange to you, okay? Don't just make the recommendation on the telephone. Send them a letter on your wonderful brokerage letterhead. Dear client, this is a non-car contract, or there have been substantial changes to the RPA. I'm not able to advise you legally on the impact of this. You might want to have a legal consultation. Dear client, there's some big cracks in the side of this property, in the ground, and I'm concerned you might want to have an expert, at least a contractor, if not an engineer, look at it. Just trying to make sure you're protected. I'm very happy to be your realtor. Signed, Helen. Signed, Art. Signed, right? So that's what you want to do, because then you have a document that shows that you did your job, that you alerted your client to the possible risks and the need for expertise. And of course, what you did at the same time was you gave them a nice piece of paper on your nice broker letterhead, and you showed that you care about them. You didn't push them away. You said, look, I'm really trying to protect you. That's what you're paying me this commission for. That's why I go to all the trouble to become educated. So, that's a great way to fulfill that obligation and at the same time show your clients how loyal you are. Here's another myth. It's just hearsay. Nobody's proven that there was a drug. Did I hear a phone go off? Does the money go to the speaker? That's what I thought. Yeah, okay, I'll collect at the end. It's just hearsay. So I don't know that there's a drug lab next door. I don't know. I've just heard. Do I have to pass that along? Well, again, knowledge is knowledge. Information is information. It might not be reliable. But I don't want to be the realtor that later, after escrow closes, my client calls me up and says, hey, Kelly, you know that house you sold me over in Duarte? Did you know there's a drug lab next door? Oops. So it was true. I think that the safe bet is, and you have to be careful how you do this, but if you hear something that may be significant about the property, it may not be proven, it may not be documented, it could be false. In an abundance of caution, I pass that information along, and I do it in writing. Why do I keep saying in writing? Because folks, your clients aren't listening to you. They aren't. They don't listen to me. That's why when I meet with people so often I followed up with an email confirming what we talked about. Because people are people, they hear what they want to hear. So when you warn them that they need to get an expert, when you tell them you've heard some possible things that may or may not be true that they might want to check into, I would put it in writing. At least put it in an email, if not put it in a letter. Okay? Because that way you can prove you did tell your client that they should check into this. So yes, just because it's hearsay doesn't mean we can forget about it. It might be true, it might be false. Here's another myth, and this is a big one. It's already a fixed issue. We fixed the roof, so we don't have to disclose it. Well, that's absolutely not true. The California Court of Appeals says if you have a repair with the property, you have to disclose it because, number one, the repair might not ultimately prove to be successful. Number two, it might at least trigger the interest of the buyer in checking a little more deeply into that issue. Well, we took the roof off the house and replaced it 3 years ago. So we had 15 leaks 4 years ago, but it's all good now. It's all good now. Well, it hopefully is. But the courts tell us we have to disclose those things. And by the way, well, I'll get to the seller's property questionnaire, but that's why we have that question in the SPQ. Now, in addition to those 6 zombie myths, which I hope you'll take with the handout with you, and I hope you'll remember to not listen to those when other people tell you that those are true, because they're myths, they're not true. There's some interesting disclosure statutes in our state. Of course, we have 2079, your statutory responsibility to inspect residential 1 to 4s. We have a disclosure statute for homeowner associations, common interest developments. That's Civil Code 1368. We also have a special statute about disclosures about deaths in the property or deaths involving AIDS. Now, in your handout on the back side of the sheet, I've actually given you copies of some of these interesting statutes. And of course, the biggest disclosure statute of all is Civil Code 1102.6, the TDS. The transfer disclosure statement is something the legislature says we have to do, not just CAR. Some specific issues of disclosure that are still unresolved. Megan's Law. Megan's Law is a very troubling law because it deals with something very emotional, very upsetting, and we don't really know what to do with it. So what happens is we require that sex offenders be placed on this website. This website, which is readily available to anybody, and no, you should not go investigate this website for your clients. Do not do this. But what's going to happen is sometimes your clients are going to come to you and they've searched the website and they've said, oh my God, there's a sex offender 2 blocks away, what do I do? Here's the problem with this disclosure statute. We don't have enough information to tell us who's at risk and who's not. Because all the information you get is the person's name and their address and the statute that they were charged under, or that they pled under. Well, the statute doesn't tell you exactly what was the demographic of the victim. Was this somebody that chased teenage boys, or somebody that chased teenage girls? Was this a child that was 12? Was this a child that was 17? We don't have that information on the website. The purpose of Megan's Law was to warn people who may be at risk. Yet ironically, the statute doesn't give us enough information to know who's at risk. I've dealt with this for clients a couple of times. I've had people who said, we have somebody in our building who is a sex offender, what do we do about this? And I looked on the website, I saw the statute. The only way I could find out anything about the people that might be in danger was by going to the district attorney. Well, most of the time those files are sealed to protect the victim. So it's a very troubling law. We've opened up a troubling issue and we really don't know what to do about it. The legislature has looked at 5 or 6 bills about 4 or 5 years ago. It was a flurry of activity and nobody really knew how to fix our Megan's Law. And because it's such a political hot item, everybody's scared to touch it because nobody wants to seem soft on crime, but nobody can figure out how to make it better. Now, I will tell you another thing about this list. Sometimes the list doesn't have dangerous people on it. Because if you make a very bad mistake when you're young, you're on that for life. You never get off. A friend of mine is on that site. He made a terrible mistake 20 years ago, pled guilty, didn't get a lawyer, went to prison for 6 years. He is a Christian man. He is a married man. He has never had any other problems in that area since that time 20 years ago. But his life is ruined because he's on the website, his picture is there, and he can't get it off. So he is not a danger, but he's on the site. So I'm not saying disregard the site. I'm saying we really don't know what to do with it. So I'm sorry, I wish I had some good news, but the news there is that's not very helpful. And I think that's one of the reasons why Carr says, don't you go investigating that site. Let your clients do it. Another disclosure law that's unresolved is, this is a wild one, the Toxic Mold Protection Act of 2001. I'm almost done. The Toxic Mold Protection Act of 2001. The mold explosion, the panic of mold, started in the year early 2000, late 1999. I'll spare you the reason why, but all of a sudden people started talking about, oh my goodness, toxic mold, it's going to kill us, it's going to kill our children, it's going to kill our neighbors. So the legislature jumped in quickly and passed this Toxic Mold Protection Act that said, and it's still on the statutes in the Civil Code, that as soon as the legislature allocates money, the state will develop a study to determine what level of indoor mold is considered unhealthful for California residents. That law is still on the books. The study is still authorized. The study never occurred. It was never funded. In the state of California today, we still do not have, and by the way, no state in the United States has a standard to tell us what amount of mold spores of what kind of mold is actually unhealthy. Nobody knows. So we're all getting these mold tests, and nobody knows what they mean because there's no standard. So that's another seminar. I got to move on. Okay, another interesting disclosure issue, and this just came up in 2010, that is the so-called upside-down property. If you are listing a property that is a short sale property, in other words, as we know, the encumbrances on the property are much more than the value of the property. Well, we know that that is not going to be a straight cash sale. We know we're going to have a lender involved and a lot of negotiation. The Court of Appeals said in 2010 that we have an obligation to disclose that up front to the potential buyer. Okay? Because they need to know when they get into the transaction, not after they've gone ahead and put a deposit and started relying, that, oh yeah, this isn't going to be a standard 60-day escrow. My neighbor next door in Pasadena has been involved in a short sale that they found a buyer 3 months ago. Well, they still have you guys know how this works, right? They still have the for sale sign up because nobody knows if and when the bank's going to approve it. So the house continues to sit vacant, as it has for 2 years now. So you've got to disclose if it's a short sale. My suggestion to you is, and I think most of you do this, quite frankly, because when I see MLS listings, I see most of you are doing this well. Just make sure you list this is a short sale property, okay? Then you're fine. All right. There are several different legal theories if we make disclosure mistakes that can be asserted against us. One is certainly fraud. One is breach of fiduciary duty. That means my realtor is a person of trusted expertise to me. They're supposed to protect me. Therefore, they're supposed to be loyal to me and tell me whatever they know that I might need to know. Okay, that's what that's about. The other one, though, is negligent misrepresentation. Now, this is where we make a representation that we didn't think was false, but we had no reasonable basis for knowing if it was true. Let me give you the simplest one that happens all the time. This house is quality construction throughout. This house has good bones. This house is well built. Craftsman quality. Okay, we can't possibly know that to be true. Because unless we're construction experts and we watched it being built, we don't know if the house was properly put together. But I see realtors doing it all the time today. And what happens if you, in your listings and your flyers, and you say quality craftsmanship throughout, and it turns out it was poorly built? Well, there's a theory for that, and that's called negligent misrepresentation. So don't do it. Don't say things that you can't prove. Because if it proves you're wrong, you can actually be held responsible for that. No, you weren't lying, but you were saying something carelessly that the buyer relied upon. Now, all these different things I've talked about today, and we could, if I had the next hour and a half to make it to our seminar, there are lots of different court cases where the courts have said, I'm going to let the jury decide whether the realtor was responsible for this issue in disclosure. That has led to this large document that we've had now, I think, about 10 years, called the Seller Properties Questionnaire. The Seller's Property Questionnaire was very controversial when it came out. But folks, I can assure you that almost every single question there, we could tie it to a published Court of Appeal precedent that involved a realtor or a seller being held potentially liable for something that none of us ever thought could happen. So that's why you have questions about pets, past repairs, trees, lots of different things, any easement issues. There are lots of different things that we might not think are significant that a buyer might find are very important. And so the Seller Property Questionnaire wraps it all together. So as I close today, what I want to urge you realtors to do is make sure, if you aren't already doing it, you should be recommending listing agents every single time. Recommend that your sellers use this SPQ. Don't wait for a buyer to ask for it. And if your seller doesn't want to do it, send them a letter. Seller, I really recommend you use the Seller's Property Questionnaire. Carr spent a lot of time developing this. It's specifically designed to make you think about issues which have resulted in lawsuits and other court precedents, and this is to help protect you. And if they still don't do it, you've done your job. Just like me, I give advice, my clients don't always follow it, okay? So I make sure I put it in writing so when everything blows up, they know they got the right advice. Same with you. They don't want to use the SPQ, make sure you have a letter, something. It doesn't have to be a mean letter, a helpful letter, but remind them it's important. Selling agents, your buyers should be asking for the SPQ every single time. I think it should be a condition of the transaction, I really do. The offer should have that as a condition. Seller to deliver SPQ. If your buyer says, no, there's too much paperwork already, then again, send your buyer a letter. Buyer, this is specifically designed to give you information that might be important to you. Now, I understand you don't want to insist upon it, but I really do recommend it, and I'm really happy to be a realtor. Okay? Why do I say that you document this in writing? Because I very strongly believe your standard of care demands that you advise your clients to use this form on either side of a transaction. And we don't want to have any of our good realtors in the San Gabriel Valley pursued by a client who says, Kelly Richardson didn't tell me to use the SPQ. So recommend it every time. It will protect your clients. Is it absolutely protection? No, this is California. People can sue you because today's Thursday. They can. Now, it doesn't mean the lawsuit's going to go anywhere. but they can sue you for just about any dumb thing. So nothing is absolute protection. But what's our responsibility in life? Just like there's no assurance we're going to walk out the street and not get hit by a bus. We do the best we can. And we go forward confidently as real estate professionals, knowing we do the best that we can, and we take care of our clients the best they can be taken care of. And beyond that, well, it's up to fate. Thanks very much for having me here this morning. I think I've